So, as some of you probably already know, I recently called the city business office of Alexandria about selling my books in public to people in the city. And the person I was talking to said I can't because it violates a no soliciting law, and that even if I gave away my books for free, it would still be illegal. I said her interpretation contradicts the First Amendment to the United States Constitution. She said I was wrong because you can sell books online. I took it personally, and as an insult to what it means to be an American. She missed the point completely. I'm looking into this, and all of the court cases back me up, which I will demonstrate here. I just want to quickly educate some people on an important court case. This is White versus City of Sparks, United States Court of Appeals, Ninth Circuit. August 29th, 2007 was when the case was decided. The whole court case will be linked in the description, but I'm just going to read basically what the case was about. The city was trying to get an artist in trouble for selling things that they didn't believe were protected by the First Amendment in public. In the end, the court ruled that the city's standard for what is protected by the First Amendment was not a legit standard, and that the First Amendment is more inclusive, and that includes anything an artist or any kind of expression created by a person is covered under the First Amendment that can be sold. And the court ruled that White, the painter's First Amendment rights, usurped the city's authority to make the determination of what is covered under the First Amendment right that can be sold. And basically the argument made by the city ignored the idea that there is a structure of both state and federal government, and was trying to put the local laws ahead of the state law. While the executive branch must both interpret and apply the law, the authority does not strip the judiciary of its authority to review laws at issue in cases properly before it to determine, for example, whether they impermissibly tread on the First Amendment rights. And ultimately, the Ninth Circuit ruled that the city applied the wrong First Amendment standard in its amendment exception to its vendor permitting policy, and hold that an artist's sale of his original paintings is entitled to First Amendment protection. So that was a very important case. Now I'm going to read from an interesting YouTube comment by Steve White on the video that will be linked in the description. I'm just going to summarize pretty much. First, it must be noted, as the court case I just talked about, the First Amendment gives protection to all forms of human self-expression, which have no other purpose but to be expressive. And in this way, the courts also make a distinction between commercial and non-commercial speech on public forums. So if you're selling your own artwork and artwork that has no other purpose but to be expressive, you should be covered. Another court case, which was St. Gaudia Society and Greenpeace versus City and County of San Francisco, reached the precedent that not only nonprofits but all people and groups have a First Amendment right to sell merchandise that is inextricably entwined with and inseparable from the conveyance of a particular political, ideological, religious, or philosophical message on public forums without a license from government. I think this is really a battle that really needs to be fought, because it's really disadvantaging to artists who are just trying to start out and want to express themselves in a creative way, but feel stifled because they're not getting enough exposure on the internet, and feel like they could get some exposure if they just went out in public and told people about their work and tried to sell it. And I do believe that regardless of what precedent was set by these court cases, any violation of free expression, such as preventing people from selling things on the street that are clearly First Amendment protected material, should be a violation of the First Amendment. Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble, and to petition the government for a redress of grievance. and also the 14th Amendment, which basically tells people that the local or state government cannot make laws that infringe the Constitution. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. And that's all I wanted to say. So long live free speech, long live art and creativity. And thank you to the YouTube users William J. Dorsett and Steve White for your comment that brought this to my attention with the citations for the court cases. It was really helpful. So that's all I wanted to say. Goodbye for now.